Hi everyone, welcome to Supreme Starters YouTube channel. And today, this is our first cognition session in English. And today's session is about sedition law, very important topic. Oftenly you see the controversy behind this law. So far, this law has so much of confusion and controversy in India, and so very important topic. And right now, I am going to take sedition law based on the question I have taken. So the question I have framed by myself, and we will see the points, important points, and how to make some answer writing which will fetch some good marks. So no answer can be said as a perfect answer in civil service exam, but they expect some common points. So if the common points are there, means definitely you will be having advantage over the other answers. So the question is, sedition law has no role in democratic state. Still, it is recommended for the security of the nation. In this context, law enforcement agencies should apply this law carefully and selectively. Comment. So the question is about comment. That means you have to give the facts relevant to what has been asked. You have to give the facts, and in the final stage, you have to give your perspective. In this case, there is no positive, negative like that. It's need not to be given mandatorily, but you have to give the facts. That is very important in this question, and then you have to finally give the answer for your perspective. I mean, the perspective which is satisfy the question what has been asked. So that perspective needs to be write down in the final answer. That means that's a conclusion. So this is the question. This question is about the sedition law in India. First of all, sedition, whether it has been mentioned in the Constitution of India or not, means it is not mentioned in the Constitution of India. Now, where it is mentioned, the term sedition definition, it is where it is mentioned, means it is mentioned in IPC section 124A, and in that some terms has been given. Let us see what is meant by sedition. So, sedition is whoever by words either spoken or written or by signs or by visible representation brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India. That means words either spoken or written or by the signs, any placards or like that, or visible representation. That means drawing, like any kind of drawings we are seeing in the newspapers. So that like drawings or cartoons. If that brings hatred or contempt or excise means stimulate. So if that stimulates or attempts to stimulate disaffection, not the word disaffection, towards the government established by law in India, that means it will be charged under the sedition. Here also there are two explanations given, explanation 2 and explanation 3. In that, what is mentioned is not all the things which are against the government will be termed as the sedition. So if that if that article is within a view to obtain lawful means, that is the keyword. So the comments which is which is criticizing the government, if it intends to bring changes within the lawful means means it will not affect the sedition charges. The same is about the third point also, and the administrative section. So in the administrative section, if any action of the government is not satisfied means, and that also within the comments, that comments is within the law means, then you won't be charged under the sedition. So for example, we are reading so many articles in Hindu which is criticizing the government's policies, especially National Food Security Act, like that we are seeing it. But in that article, so what has been told is it pinpoints the drawbacks of the scheme. Though it is criticizing, it doesn't bring hatred or contempt or disaffection towards the government. That means one policy is taken and that was criticized for its shortcomings, so that the government can improve. So that doesn't come under the sedition. That won't attract the sedition charges. So here in the sedition, the most important things you have to remember is hatred, contempt, and disaffection. The key word is disaffection towards the government. So most of the people, what they do is disaffection towards the country. So that means they will misunderstand like that towards the country, towards the nation. So that is not the sedition. The sedition means disaffection towards the government established by law. That will attract only the sedition. So this definition you have to answer. Definitely, and in your answer writing, you have to mention this definition also. So why we have taken this question is 279th Law Commission of India has recommended for extension of the sedition charges, and even it recommended for the punishment to be extended. Punishment, that means that imprisonment currently it is 3 years, and it is recommending to increase it to further to 7 or 10 years. So why it is recommending? Why the sedition is needed? First, that needs to be answered. India's unity is prime importance, and India's security. So nation security. So national security is very vital for a diverse nation like India. That is why they are arguing for the sedition law to remain in India, to be continued. They should not be abolished. Sedition law should not be abolished in India at all. And this is the prime reason. National security. This is the prime reason why they are arguing in favor of sedition law in India. That means if sedition law is taken, means some kind. So people for these fringe elements like these communal elements, these fringe elements, they will have some very easy way to do their propagandas. So this will create, though it will start against the government, it will ultimately erode the unity of the India, and security of the nation will be compromised. So that is the main reason you have to write the answer in your answer writing why it is arguing in favor of the sedition law. So national security, that is very important. Now we will move to what is the recent controversy and why we have taken this sedition law. And recently S.T. Wombatkare is a retired army general. He has filed a case against Union of India, to scrap the sedition law. And why he has made this case is he's saying that sedition law is against the democracy, and it is against the freedom of speech or freedom of expression, which are guaranteed by our constitution, fundamental rights. So he is arguing that and also he's of the view that this sedition law is widely misused by the enforcement agencies. So they are not even understanding the sedition meaning, and they are using it very not all the cases which are not need to be booked under the sedition law, they are booking it under the sedition, and that makes more confusions and controversy in India. And for this reason only he has asked for the scrapping of the law. And Supreme Court it also ordered on the freeze of all the current cases which are being heard under the sedition law, and also asked not to file new cases under the sedition law till the judgment is given. So all the cases which are already booked under the sedition law, and also new cases won't be booked under the sedition law. So that is what the Supreme Court has ordered, that till the clearance that the sedition law's controversy or confusions is getting cleared, no cases will be booked under the sedition law. Now we can before going into this sedition law, we have to go the historical things also. That is what I have already mentioned. The facts should be mentioned. The facts should be gone through, or it should be written before we will go into the conclusion. So this sedition law, when it was introduced by the Thomas Macaulay during the British period, and initially it was against the Deobandi scholars. It was introduced, but it was mainly used in the 1897 against the Bal Gangadhar Tilak. So this is very important famous case where Bal Gangadhar Tilak versus Queen Empress. So this is very important case. In this case only, the first thing or first judgment regarding the sedition was given in India. So this is the case where Bal Gangadhar Tilak has his own magazine that is called as Kesari, which is written in Marathi. So that is a weekly. So you would have known Kesari, a Marathi weekly. So during the 1896 or 97 period, India was facing a severe famine, and in that famine, so a lot of people died due to the hunger or poverty like that. However, British government it continued to increase the taxation on Indian farmers. They didn't care about the famine's effects, or famine relief is also not that much good. So against this only, Tilak has written one poem using this Shivaji, the Shivaji, the great emperor of Bombay. So Shivaji Utterances, that is the poem name. So in that poem, what he has written is, it was like Shivaji was awakened from the sleep in heaven, and he said that India is now facing a severe famine, but the government policies are not good for take care of the people. Also, there was an oppression on women, oppression on the farmers or small artisans. So if it is not corrected, means then British government will be thrown out, like that. Authority will be thrown out, like that. That poem has been written. So Tilak wants to is constructively criticize the British government. He doesn't want to create a rebellion towards the government. He was criticizing the government policies. So because of famine policy or government policy during that period, it was not enough for the welfare to take care of the people. So that is only he has criticized. But what after the poem has been written, after 1 week, that famine relief officer, W.C. Rand, actually, he has been killed. So British government has charged him under sedition and said that he has created a bad feeling towards the British government. So in that case, Justice Staunchi was the judge, and he said that creating a bad affection towards the government, then it will attract the sedition. And the same has been the verdict has been challenged in the Privy Council also. So the Privy Council. The Privy Council. Privy Council means it's like a Supreme Court during that period. So the Privy Council has upheld the Justice Staunch's decision. I mean, is verdict. They said that creating a bad feeling, any kind of bad feeling towards the government, then they should be punished under the sedition law. So Tilak was again charged in the 1908 for a different reason. But however, this is a major landmark judgment which was given against the given against the Tilak under the sedition law. So any kind of laws written, it was judiciary's interpretation. It is very vital. Whatever the judiciary or judge has interpreted, it will remain as a precursor for the follow-up judgments. So the initial thing was creating a bad feeling towards the government. That itself will create it will attract the charges of sedition towards the people. So you have to note one thing also. Another thing, the sedition this is one of the question. This is one of the first case, and later on this Dutt Majumdar, which is emperor. This is also during the British period. But in this case, what was the verdict given was somewhat different from the Tilak case. So in this case, judge what verdict he has Gayer. I mean, his name is somewhat Gayer, I think. He gave the judgment that if a person is to be charged under the sedition, then it should have some anticipation of creating public disorder. I mean, like the public disorder should have been affected. I mean, it should have created the public disorder, or it should have some kind of anticipation of creating the public disorder. Then only that person can be judged under the, convicted under the sedition. So it's very, very important because for Dutt Majumdar case, that creating the bad feeling towards the government, that was not taken into consideration. Only if the activity or if the gesture creates a public disorder or an anticipation of creating a public disorder, then they can be created. Then they can be booked under the law of sedition. I mean, sedition law. So these two are very, very important cases with respect to the sedition interpretation. So sedition laws interpretation. These two cases are very, very important, and this was given by federal court. The judgment was given by the federal court. These two cases you have to mention. Then only you should move your answer further. So after the independence, during the independence, during the draft committee who are preparing for the Constitution of India, they have deliberately removed the sedition law. They have not included the sedition law because it touches upon the fundamental rights of right to freedom and freedom of speech and expression. So they doesn't want to include sedition in the Constitution of India. But Law Commission of India, they have recommended because of the country's national security and also the unity of nation. So that was very important. So only Law Commission of India during that time itself, they want to retain the section 124A, that means the sedition law. So after the independence, one of the very important cases is Kedarnath Singh versus State of Bihar. It's very, very important case with respect to the sedition law because it does determine this case determined the constitutionality of the sedition in India. So whether constitutionally it is correct to retain, the sedition law is constitutionally correct or not, that was answered in the Kedarnath Singh versus State of Bihar. So Kedarnath, he is a communist actually, and he was of opinion that that the sedition law, it is against the fundamental right of speech or expression, so it should be removed. That was the case. But also, so that was the case booked, and Supreme Court actually they have favored the sedition. They have said that the sedition law is within the ambit of Constitution, and because of the two reasons. So two reasons they have indicated. The first reason is the terms state and government. It's very, very important. So before going into the Kedarnath Singh judgment, you just want to know about the state. Know the word, the capital letter S, it denotes the nation. The country. The country as a whole, the state, the word state defines. So that state consists of population, territory, sovereignty, government. So government is one of the elements of the state. However, in the Kedarnath Singh judgment, what they have told is, so this the sedition charges, actually government represent the state. Government is it resembles the state. They have said like that. So if government is subverted, means then state's existence will come into trouble, or it will come into jeopardy. So that is what the first statement was about. So they have equated the government versus state in the Kedarnath Singh versus State of Bihar. And the second thing what they have told is, you all know about the Article 19.2, which imposes some restrictions on our freedom of speech and expressions on the interest of national security. So on the interest of national security and also for the welfare of the state. So what they have told is anything against the government, it can be equated with the state also. So Article 19(2) has reasonable restrictions on the right to freedom of speech and expression. On the same ground or on the same basis, sedition law can be continued in the India within the ambit of the constitution rights. So I mean within the ambit of the constitution. So this is one of the very very important cases. You have to write down what under all the things I have mentioned. You have to write down. And in the Kadarnath Singh case, what it was mentioned already, also is the sedition will be charged only if it creates or if it try to incite some violence. So if violence is created means then sedition can be used, or some reasonable anticipation of violence will be created by that activity or by the gesture means, then they can be booked under the sedition law. So the Kadarnath Singh is a state of Bihar. You have to definitely mention one point. That means the government symbolizes the state. I mean the government symbolizes the state only. So if government is subverted means state's existence will come into trouble. So that is one point. And second point is Article 19(2), which imposes some restrictions on the basis of national security. So that sedition law can be brought under the Article 19(2) also. So that was the main reason they have told. They have defended the sedition law in Kadarnath Singh versus State of Bihar. So what happens next is you have to come towards some kind of conclusion. That is very important. So in this case, national security is very important for very vital for the nation like India. However, the argument, the strong argument against against the sedition law is it is getting misused. Also, whether in the democratic state it is needed or not. So again, the democratic state has to exist. So the state has to exist. The sovereignty of the country, it should be authority of the state should be protected. Otherwise the nation would not exist. So sedition, in current situation, India definitely needs the sedition, but what it needs is the law enforcement agencies. They should be sensitized about the sedition. So what kind of cases will attract the sedition? So for that, the law enforcement agencies, they can create a separate cell or separate body for that for the sedition cases. Like if anyone is going to be convicted under the or anyone is going to be accused under the sedition law means, then it should be brought into the control of that separate agency. That separate cell should be there who consist of the experts with respect to the sedition law. So then they should analyze it and they should consider the particular case whether it can be booked under the sedition law or not. Like that, they should definitely go through the complete SWOT analysis before booking a person under the sedition law. And then after that, when it comes to the court also, the court also should have a separate body to case of the sedition cases, because sedition is very important. It is against though it is it creates disaffection. So one thing is what we can say is in a democratic state, affection towards the government, it doesn't need actually, because even the government can be overthrown by the people of India. So why kind of affection is needed? So that is not needed. So this kind of words, disaffection, these kind of words need to be can be altered. Altered or any other replacement word can be brought into the section 124. So this is with respect to the lawmakers. So you have to separate it with the lawmakers, some kind of words. So disaffection. So like that words, they should get some alternative word, or they should modify the law with respect to these things, because affection or disaffection in the democratic state, it doesn't need at all, because disaffection towards government means it is a vague word. It will create a lot of trouble. So it needs to be specified and needs to be point. It needs to be like on to the point. So the confusion of the starting points itself can be easily erased. Then what needs to be done is law enforcement agencies, they should be sensitized. That is the second point. And also they should create a separate cell for the sedition cases. And with respect to the final thing, before the conviction, we should have a separate body. Separate judges for the case of for the cases handling the sedition. So these are very very important things you must remember. So start your answer with the definition of sedition, then go for why it is needed. So 279th law commission, it has argued in the favor of sedition law to be retained. Why it is so? It is of the national security and unity of India. It has recommended that, because you can throw some points also, like we have communal violence still in India. So that is one of the prime reasons. We have some fringe elements also. So for that reason we definitely need the sedition law. Then you can go for that case studies. So cases definitely you have to indicate that will give you high marks, like Ombatkare cases with Union of India. Then with a historical point of view, go through the Tilak case versus Queen Empress case, and then Dutch Majumdar versus Emperor, what has been given. And in Kadana Singh versus State of Bihar also is very important case. So these cases should be written, or on whatever the court interpretation given on the sedition, it should be written down. Then difference between the state and the government, it was given in the Kadana Singh also case also. Then you go in the final stage, you go for the conclusion. So what under all the changes we can brought under the section 124A, also with respect to the sanitization of the law enforcement agencies, and finally before conviction, that judgment, the judges should have a separate expert towards hearing the cases of under the sedition law. So this is with respect to the sedition law. And do write your answers and give it to the mail. Our mail ID has been given in that channel bio. I mean in information, channel information, we have given that link also. Also, please do visit our Telegram also, so that you can get out of the notes. So if anyone is interested in writing the answer for this question, means it's very welcome. Please do write and give your answers, send your answers to the mail ID. So I will check the answers and I will give my suggestions also. So nobody is perfect with respect to the mains answer writing. However, it's a practice. Only if you practice, only if you write some answer writing means, then only you can improve yourself. Those who cleared the prelims or those who didn't clear the prelims, it doesn't matter. Start your answer writing. It's a part of process. As Dhoni has said, it is a part of process. So you should write your answers. And so this is about with respect to the sedition law. So give your suggestions. Do subscribe and share. Also, do give your comments also, so that I can improve myself. So Telegram channel, Instagram links, everything is given in the channel bio also. I will post it in the description also. So this is with respect to the sedition law. Thank you very much.